Thank you, everyone, for joining us. I hope everybody had a great Thanksgiving. My name is Ari Rothman. I am a partner here at Venable, and I travel in between our DC and Los Angeles offices. I'm joined by Shahin, Rothermel, and Berge, my partners, and we are all part of the Venable Autorenewal Solutions team. And this webinar covers basically various aspects of that. So this is right in our sweet spot, and we're happy to share this presentation with you this afternoon and answer any questions. You can always contact us at phone numbers or email addresses here after the webinar if there's any follow-up that you'd like us to weigh in on. With that, should we go on to the next? Here's our agenda. It's pretty simple. We're going to talk about the Federal Trade Commission's negative option final rule, the challenges to the negative option rule, what's next and what we anticipate there, and changes to California's amended auto-renewal law. For those of you who might not already know this, the implementation of that has been moved to July of 2025, so there's still room for changes. But we'll get more into that at the end, on the back end of this presentation. So now I will turn it over, talk about the negative option final rule and overview.
Okay, I'll take it from here. Hey, everybody, I'm Berge. I'm going to kick us off with an overview of the sort of more significant points in the negative option final rule that the FTC released. We will cover as much as we can, but the FTC statement of basis and purpose around the rule is extremely long and detailed and goes through a lot of commentary that the FTC reviewed and evaluated and considered. And out of that commentary, it'll show you a little bit about the rulemaking process at work. Along the way, we'll talk about some initial proposals that were put in an earlier draft of the rule that actually the FTC decided against. So some helpful notes there. But, you know, largely the rule stayed intact with how it was originally proposed. And so there's a lot of commentary, a lot of detail to always seek out in that. And so we recommend that if this is truly in your space, you should take the time to slog through that. But today, where we're going to focus a little bit is just to give an understanding of how the rule has expanded. A big thing in consumer protection law is always disclosures, and on top of that, clear and conspicuous disclosures. So we're going to learn more about this newer updates to, you know, how that would be defined. There are, I think this third bullet point down here, this issues with disclosing material facts about the offer are really important. We're going to talk about that a lot, because the twist here is that this rule has things in it where, of course, you would make disclosures about the negative option offer. We'll talk about all this, but there is also a prohibition on misrepresenting any material fact about the underlying good or service that is subject to the negative option offer. So to us, that seems a little bit outside the scope of directly regulating the negative option offer and looking, you know, at other claims that could be made about a product or service, and potentially here now, not even potentially, likely, a new tool for the FTC to get penalties and monetary relief for unfair and deceptive claims about a product or service that maybe it has currently some struggles getting on past practices. So we'll cover that a bit. We're going to talk about what it means to get consent to the automatic renewal offer or the negative option offer. And then, of course, the big one, click to cancel, very catchy, but we are going to talk about what click to cancel means and doesn't mean as we go through this. So there's your overview. So next slide. Okay, so real brief history. This rule is sort of based off of, or it's a great expansion of a previous negative option rule the FTC has enforced that was really just focused on a very limited type of negative option offers they were pre-notification negative option offers. So pre-notification meant that the company would send you a notice in advance of a selection of the month, think book of the month or something like that, and you would have an opportunity to reject it before accepting it and having it sent to you and paying for it. That is still part of this, but really the focus here are going to be on subscriptions, automatic renewals, membership clubs, continuity programs, free to pay conversions, or fee to pay conversions, a nominal fee to pay conversion, like an introductory offer or a free trial offer, where somebody gets in very early. Maybe it's free, maybe it's, a small, a small price. You get a chance to try the product or service before you have to pay for it at full price on an ongoing basis. So it's called negative option because it's really about the consumer's silence or failure to take some affirmative action to reject goods or services that are going to keep coming to them, but a lot is wrapped up into it. So that's what we're dealing with here. On the scope, you have to think about how offers are made these days. There are often it's going to apply to anything that really in a vacuum or in its own bucket is a negative option offer, and that could be something that's an upsell. It could be sort of a sale that starts as a one-time sale, a one payment, one-time sale for a good or service, and leads into an upsell offer for maybe a service contract or something like that that could be tacked onto it. So when you get to the upsell part of it, disclosures need to be made, consent needs to be made, all of the requirements that we'll talk about need to be covered. Bundled services are also going to be covered. This has always been sort of a consumer protection type of pitfall, bundled services. Sometimes it's confusing for consumers to know if they're purchasing a product or service, even if it's something on a subscription or automatic renewing basis, they might get offered another sort of set of services by the same seller in a same transaction, but it's a different program. And so again, making the disclosures, getting the consent, allowing cancellation appropriately for bundled offers is something that's going to be covered here and needs to be considered. What it doesn't apply to would be an installment contract. So the FTC was fairly clear about this, but I'll put an asterisk on it for a second. But an installment contract, think about a consumer making a commitment, a year-long commitment to get goods or services throughout the year. Perhaps they agree to pay monthly or they agree to pay quarterly, but they agree in advance to make the installment payments for a year. And at the end of that year, it's over. There's no automatically renewing the agreement for another year on top of that. It's just a straight installment contract. That is not the type of thing here that, at least how we read the rule, that the FTC meant to cover. However, if that installment contract did renew for another year on top of that, it is going to be covered. It's that automatic renewal piece of it, of this transaction, renewing for another year, another sort of set of quarterly payments or whatever the commitment is going to be covered. One more piece here to mention, we don't have a bullet on it, but many of you may also be interested in whether this will cover business-to-business transactions, and it would in large part. So potentially contracts that are executed between businesses could be covered with respect to the automatic renewal nature of the agreement, and a lot of business-to-business agreements do automatically renew. The FTC is going to be more likely to enforce this rule in situations where the business agreements are form contracts that are usually used, especially with smaller and medium-sized businesses on the other end of the deal, who don't often have a chance to negotiate the terms, and they just have to take it or leave it. If those have automatic renewing provisions, And the example that I can think of here would be a payment processing merchant services type agreement that small businesses would frequently sign. That's the type of thing that the FTC seems to intend to cover under this rule. But of course, a large contractual transaction negotiated by two very large sophisticated parties with lawyers involved, and you're actually negotiating terms and renewal terms and those types of things is not likely to be where the FTC puts consumer protection enforcement resources. So you can think about that there. I don't know, anything else I'm missing, Shahin or Ari, on scope before we go into requirements?
No, I agree with you. I think that the purpose of this rule really is to expand the scope to get everything. And the one thing that they did say in their notice in the preamble was that it doesn't apply to installment contracts. But other than that, there's really a question of what does it apply to. So Ellen, you and I had this issue the other day, which is reloading. For example, if you have a digital payment card, or I have my coffee place I go to every day and I order online through the app, and it auto renews. I would say it auto, I guess, re-ups the amount of money that I have there. And there's questions now whether or not this rule would apply to that, because the negative option rule previously was very, very narrow, and now it is very, very broad. So I agree, Ellen, this is the FTC's attempt to probably try to get money as much as it can after the FTC's loss in the Supreme Court case in AMG, where the U.S. Supreme Court said you can't use your general authority to get monetary restitution or penalties. So I suspect we're going to start seeing use of this one a lot.
I agree. And we've seen, I think the FTC will use this very widely, broadly, and liberally for a lot of different practices. So we'll have to watch and see how this plays out, assuming that it survives challenges, which Shahin will talk about a little bit later. So, all right, let's keep going. We'll talk about some of the sort of technical requirements. So disclosures need to be made about any sort of automatic renewal offer, negative option subscription. And it's stuff that we've talked about it a lot: pricing disclosures, the fact that it auto renews in the first place, and that the consumer has an obligation to cancel it to avoid further charges. But how you make those disclosures is always such a critical analysis. It's important whenever you're setting up these disclosures to think these things through. There are sometimes competing state laws and viewpoints and interpretations of what is clear and conspicuous to think through. But what we have here is sort of the FTC weighing in a little bit more forcefully on clear and conspicuous disclosures. Clear and conspicuous, it always means sort of easily noticeable, difficult to miss, easily understandable. But here in this rule, the FTC was very specific about, the means of disclosure. So if the communication is only a visual communication or only an audible communication, the disclosure must be made through the same means. Think about television ads. Both are visual, and the television ads are both visual and audible. And so in that case, the disclosure has to, according to the rule, now be presented simultaneously in both the visual and audible portions of the communication. I think that's going to be, this is new, I think, and we'll have to see how this plays out. But think about an ad for a streaming content service on your TV, and there's often introductory offers, things like that, for pricing, and a lot of times disclosures could be made, and we've gotten to a point where disclosures are a little bit bigger now, but they might just appear on screen. But now disclosures need to be both visual and audible. So we'll see some changes here, I think, to television ads. Visual disclosures, of course, need to be sort of stand out, visible. If it's on a screen, a television screen or another ad, it's got to, be there long enough to be read. Those types of things all still are in play here. And then audible disclosures have to be delivered in a, in a way that somebody can actually hear it and understand it. So no auctioneer voice is what we always say, and that still holds up now. So move.
And that's something, sorry to interrupt. I was going to say, and that's something that we're starting to see in all of the FTC's proposed rules and final rules, is this new definition of clear and conspicuous disclosures. And I think that part of this has a lot to do with social media and online viewing. So if you're looking at stuff through an Instagram video, if you're looking at things through YouTube, if you've got TikTok going on, this idea of mirroring, the claim is made one way, mirror that disclosure so that it's made in the same way that the claim is made.
Okay. Again, okay, now we get a little bit more to sort of these interactive electronic mediums, which now has a definition, which we'll get to, I think, in a second. But so again, disclosures have to be unavoidable. Really, like, no scrolling, not at the bottom of anything. It's got to be before it can see the button to click through to the next action. If you want to think about it that way, it shouldn't be too far removed. Using an asterisk and then putting disclosure somewhere else is really challenging to get to compliance with that type of thing. So keep that in mind. Using words that are understandable, diction and syntax, that regular people are going to understand is it shouldn't be too hard with these types of disclosures, but you really just do want to explain it in plain English. A lot of times we're playing around with language to make something shorter to fit or whatever. And conversely, you don't want to make things too long either, because you don't want to have consumers see this long chunk of paragraph text that they don't want to read. In fact, the FTC has brought dense disclosures up as problems, but easy to use words and things like that you want to cover there. So okay, disclosures must comply with these requirements in each medium through which it is received. So electronic disclosures have to sort of, for that mode, you have to make sure that these things are all met. Face-to-face communications, I suppose, could still be covered, perhaps, and think about over the phone. Phone sales a lot for automatic renewals still occur. So again, it's making sure the scripting covers all the points that need to be made here. We go back to sort of the clear and conspicuous audible disclosure type of issues there. Some other couple things to round this out, but you cannot contradict your disclosures and telling somebody about this automatic renewal with anything inconsistent in the transaction. Inconsistency, by the way, might happen much earlier. So think about an intro ad or teaser that leads somebody over to a website. If that teaser is misleading, it's really hard to roll that back with disclosures on the webpage. So you want to think about what can you do up front to make sure people see this great deal, but understand that, it auto renews. At least get that far with it so that you've got something kind of later on to latch on to continue through the theme. And then, again, another number 8 is also not a new theme, but just reinforced here that, you're speaking to your audience. So if you're targeting older adults, for example, make sure you take that into account and make sure the disclosures can be heard or viewed by that group.
Agreed, Ellen. And I think one thing that we always have to keep in mind is the reasonable consumer is going to be viewed from the lens of the FTC and not necessarily the people who are on this call who might be more sophisticated and educated than the way the FTC views people. The way I tell people is think about a disclosure that's being made to somebody with a middle school education on reading, somebody whose English might not be their first language. Even if your ad is not in another language besides English, you have to remember that people who are ESL, English as a second language, might be viewing it. So I always think about it from the perspective of my mother. So being really mindful of those types of things. And one thing that we've been talking about a lot over the past week or so has been hyperlinks. And not a lot of people have been talking about. The name of this webinar are the unsung changes, and I think this is a really, really big one, which is, what about hyperlinks? We talk all the time about whether or not you can make disclosures via hyperlinks. Somebody has to hover over something. They have to click on something to see a disclosure. In the proposed rule, there was a sentence that said, a disclosure is not clear and conspicuous if a consumer must take any action, such as clicking on a hyperlink or hovering over an icon to see it. And this is crucial. The FTC deleted this in the final rule. They had a lot of people, a lot of commenters said, we have to use hyperlinks. You're telling us we have to disclose all of this stuff, and Ellen's going to talk a little bit more about all the stuff that you have to disclose. But you're telling us that we have to disclose all of these various things, and it's just, you've got disclosure fatigue at some point. It's going to undermine the efficacy of these disclosures. And so in the final rule, if you look at the preamble, the FTC went back and actually took away the language that you saw here, this idea that a hyperlink is not acceptable. It said this prohibition would have made effective space-constrained disclosures of the terms required by the final rule difficult, if not impossible. However, a clear and conspicuous disclosure still must be, quote, unavoidable, meaning it can't be buried or inconspicuous. So what we're starting to see now is some tension with what the FTC and other regulators say are effective disclosures via hyperlink versus what's happening now in the final rule for negative options, where the FTC really says it's all got to be laid out, massively dark, on a page, prominent. So I'm really interested to see how the FTC actually enforces this. But one thing that we on the defense side, Ari, Ellen, and I, we have class action cases, we've got FTC cases, we've got state AG cases, we've got cases for the California Autorenewal Task Force. This is really helpful for companies. This idea that the FTC considered prohibiting hyperlinks altogether and has now said, well, maybe in some circumstances that will be okay. So something to keep in mind. Keep your eyes out, because I have the feeling this is going to be something that we'll see more of. Ellen, do you want to talk about the?
Sure.
Oh, wait,
so,
Ari, hold on, Ari.
Sorry,
Ari.
Leverage that in the consumer class actions too. I mean, it's not the law, and the fact that they deleted the sentence doesn't mean that it is the law, but it is something to point out when you're responding to demand letters and judges say, look, like, because we have a space constrained conversation all the time. I feel like we have it every day with either a class action lawyer or the government, either state or federal. And this is finally, they've cracked the door open, albeit just this much in a narrow circumstance, to have this space constraint discussion, because we've been waiting for this, I feel like, most of my career. So this is something to watch and leverage. It's not positive, it's not as big as maybe we're highlighting it, but it to be, but it's not nothing.
okay, so material facts and material terms. Now, let's do material terms real quickly. And I want to focus on material facts for a second. But material terms, this is sort of the crux of your disclosure elements that you've got to make. They have to be disclosed immediately adjacent to the consent mechanism. It's going to take some time to sort of play around with how these look. For a long time, we would put one way to do it could be a checkbox next to your disclosure. Maybe that works here, maybe it doesn't, but the main things that have to be disclosed, the material terms about the automatic renewal feature, remain pretty much as they have been. So you're still disclosing, that a customer is going to be charged on an ongoing basis, or if they're in a trial period and after that ends, if they haven't canceled, they're going to be charged more unless they cancel. So when they have to cancel by, the deadline, by date or frequency. So by the 30th of the month, or before your subscription renews on the first week of every month, whatever it is, you got to be precise enough and clear enough, how much they're going to pay, and then information necessary for them to find the simple cancellation mechanism that is required by the rule. And this will be an interesting point that dovetails with a lot of state law requirements that are very specific on providing a certain kind of cancellation mechanism. And when you read these over carefully, you may not need to disclose every single ounce of information about how to follow the cancellation mechanism in your disclosure. In fact, that makes your disclosure really long. But letting the consumer know that you can cancel online through your account, whatever it is, like something concise and accurate and simple is probably what you're going to go with here in an effort of being clear and sort of conveying the information necessary for them to find the cancellation mechanism and easily cancel. So Shahin or Ari, anything to add there? Because I want to talk about material facts next.
No, I agree.
Okay, so material facts. So this is that piece that I said at the beginning, where now you are obligated to not misrepresent any material fact about the underlying good or service. What is material? So material is really, and it's defined, these are not the defined words, but it basically is defined as any information that's going to affect a person's decision on whether or not to buy the product or service, or whether or not to get into this automatic renewal feature in the first place. So to me, this could get squishy and a little bit subjective as to what's material or not. So it's going to be something that you're really going to have to think about for your product or service or offer. There could be an element of it, for example, if your arrangement has some sort of termination fee, you let somebody go on with this, but if they want to cancel before a certain amount of time has passed, you're going to charge them a termination fee. I think that's going to be an example of a material fact. But material facts could also be important information about the purpose of the product, or the efficacy of the product, or does it work, or who's if it's training, who's providing the trainer, are they qualified? It could be a health or safety issue. It could be all sorts of things that are not really in the zone of sort of the automatic renewal mechanics itself. So you do want to keep that in mind. I think another example we've talked about is actually who is the merchant of record, meaning who is actually going to charge your card. Whenever you go through this, there's a sort of a lot of services out there that will provide a merchant of record type service. Another risky business to discuss for another time. It's been separately the subject of other FTC and law enforcement, but in some cases, when you go conduct a transaction on a website, the entity that's charging your card isn't actually the brand name that you thought you were buying from. It's a merchant of record. So all of these things could potentially come up here.
And I agree. I just want to jump in. And I think that this is another area where the FTC is going to start using the negative option rule to get money against false, unsubstantiated claims, endorsements, testimonials, like all of that. I think the FTC is using this as a way to really hook that in. So if you're doing anything on a negative option basis, you're now on notice that essentially any claim you make is going to be subject to this rule, or the FTC will say it is. I disagree with that. I think the rule is far beyond the scope of what the FTC can do, but that's what the FTC's position on this.
Okay, so obtaining express informed consent. So you have to obtain the consumers or your other transacting parties express informed consent to the negative option offer, and that has to be done separately. So I'll ask Ari or Shahin, does this mean like two consents, like one for the negative option stuff and one for your privacy policy and terms and other stuff? I mean, what are we looking at here?
I think that's what the FTC is saying here. I know that we're going to talk about whether or not a checkbox is required, but I'm chomping at the bit because that's something that's really fascinating to me.
We'll put in a footnote that you have to keep records of consent for at least 3 years, but maybe go to the next slide.
That's right. Yeah. And what is, but the question really is, I think that we're asking here is what is consent and what is separate from any other portion of the transaction? I mean, consent can be made in a whole lot of ways. Courts are going to have to grapple with this because I don't think any court, Ari, keep me honest here, we've got all these FTC orders and California orders that say you have to get consent separately from any other portion of the transaction. But I don't know that there's ever been, any type of action brought for a violation of one of those injunctions. So no court has really grappled with that. My theory is that there's ways to get that consent along the enrollment funnel. It doesn't necessarily need to be through a radio button or a checkbox, but I'm interested to hear your thoughts, Ari.
It could, yeah, I mean, I actually could see a variety of circumstances where you don't want to get consent for the privacy policy terms and this express informed consent for subscription and related terms, because that's going to be confusing, and I think some courts, particularly in California, might have a problem with that. I think you can get it through very rarely these days do we see like a one-step process for a purchase. So I think it's better, especially given all the privacy litigation, which we'll talk about some other time, to get that form, to get that agreement and consent on the front end of the transaction, and then get this consent separate and independent later on in the transaction. We have had government entities tell us, I mean, their first position is don't get consent with the terms, for the terms and the privacy policy in the same box, and then we think we've convinced the same regulator through a lot of negotiation that we can do it, it just has to be later, but that same regulator is the one saying there has to be a checkbox, even though, we'll get to this, I guess we talk about California, we feel pretty strongly that the law doesn't absolutely require it. So I think separate consent can be obtained in a multi-step funnel by itself. I think it should be. I think it can be done without affecting conversions based on what my clients are telling me, our clients are telling us. And this probably can be navigated. This is probably doable. And I would keep it for 4 years if you have a bunch of sales in California, by the way.
Yes.
Right. Yeah. So the negative option rule is 3 years. That's a requirement under the negative option rule. But as Ari is saying, 4 years is helpful to defend yourself because that's the statute of limitations under California's unfair competition law, which is where we see California auto renewals challenged. So keep your records, long story short, so you can defend yourself.
And I don't want to gloss over the second bullet, actually, which I almost did, but it is important to make sure that you're not detracting from the consumer's ability to provide their express informed consent. And it's like informed is a really important concept. They have to have been able to read the negative option disclosures and understand them and agree to them. And if you've got a whole bunch of other like language in there and terms and it's overly marketing and whatever, it's going to be viewed as a detraction, I think. So anyway, that point too. So the next slide, I think, Shahin, is on the checkboxes. So is a checkbox required?
So I think we're still going to be grappling with that. Courts are going to be grappling with that. My theory right now is that we could probably defend, if you've got the right consumer experience, you could probably defend not having a separate checkbox, radio button, or similar type of action. That is going to be so fact specific, though. I don't want people to call me up after this. I know I'm going to get a bunch of calls from people after this. So that's going to be very fact specific. But one thing that was interesting is that the final rule is different from the proposed rule. The proposed rule had all of these disclosures that needed to be directly adjacent to the consent mechanism. And I know what the FTC is thinking. They're thinking there's a checkbox and then all of the consents related to the negative option offer. But the problem is that they say all material terms, as Ellen said, have to be disclosed. So what, do I have to have a checkbox saying, I agree to be charged on an auto renewal basis. I agree that the endorsement on page 2 was a paid endorsement who has a material connection. I agree that the average consumer is going to lose 2 to 3 pounds a month as opposed to 10. So what the final rule did was it took out those sort of crass examples I gave at the end there about the endorsement and the weight loss and just said, essentially, adjacent to the consent mechanism needs to be the negative option, like the billing. I call it the billing disclosures, right? That's what people really care about. What am I going to be charged for? What, when, how do I stop, right? And so I think that's really what the final rule is going to get at here, is that that's what needs to be directly adjacent to the consent mechanism, and information that is not directly related to that just must appear before obtaining their consent to the negative option, which makes sense if you're going to do that later in the funnel. If we're going to have material disclosures about things like the endorsements or typicality, things about the product, that we're going to do that before you collect that payment information and get consent.
Okay, real quick, I'm gonna pause and give the CLE code. It is Auto Renewal 2024. Auto Renewal 2024 is your CLE code. Which I never remember to do, so I'm happy I did. Okay, so annual reminders, this will be a quick one. There was a proposal that annual reminders should be sent to consumers to remind them that they're in this sort of recurring charging them program. That has come out, but keep in mind that you might face some state law issues there. I believe Colorado has a law, for example, that does require annual renewal reminders, even if something is charged on a monthly basis at the year marker. You're supposed to send something to people reminding them that they've been charged every month and are going to continue to be charged. So keep that in mind. Let's go next to the cancellation requirements. So again, guys, it's no secret that you've got to give people a way to get out of these things. And law that has built up over time, state law and otherwise, has said that it has to be simple and easy to find. The rule here is looking for a cancellation mechanism that is in the same medium that was used to consent to the negative option offer, and that it is easy to use. So we can flesh that out a little bit more on the next one. So if somebody signs up online, they have to cancel online or really through some sort of interactive electronic medium. And online means app or some other way. But has to be easy to find. So you can't have somebody go to a website, start looking around, what link do I even start at? It's probably okay to have them go into my account, but at that point in my account, you're going to need to make it pretty easy for them to find the here's how I cancel my subscription type of link. I'd avoid a lot of steps, you know, you know, hey, contact customer service, and what do you want to talk to us about today? And you give them 15 different potential reasons that they might want to contact you. And maybe at the end of the list, it might say something like manage my subscription, and then they have to go. So you just have to be mindful and think about how many steps you're putting in there and make it easier to do. This is an interesting one to me, is that a key thing here is that they say for these interactive electronic medium cancellations, in no event should the customer be required to interact with a live or virtual representative, like a chatbot, if they did not do so when they were consenting to the negative option feature. However, you can, if you can, theoretically, you could find a way to allow people to cancel through chat or text or email, or some other way. So if you're able to craft a chat in a way that is, you know, clearly labeled, and maybe when the chat box pops up, managing a subscription and then canceling your service is really early in the process and doesn't require a lot of like typing and interaction, maybe there's a way to do that. But anyway, I wanted to point that out because we've had a lot of questions over time about whether chat was an acceptable way to cancel. I don't know if any other comments on that from Shahin or Ari, but it has come up.
No, I agree. I think that's, and then like how do you use AI? And then Ari, I know there's all the chatbot, so you have to think about like SEPA, like there are a lot of lawsuits that are challenging the use of chatbots generally and the collection of information. So a lot of interaction among all of these things. Just keep those in mind, that this isn't just, you got to keep your head on a swivel, 360 on this.
Phone cancellations, you know, have to be affected quickly enough. You should be answering your phone during normal business hours, which to my knowledge are not defined, but your normal business hours shouldn't be like 2 hours a day on, you know, on off days. Make them like regular hours for the most part. if you can allow people to record a message, you just have to be able to pick the message up. That's a tough one to me, because somebody could leave a message and not leave any identifying information about themselves or whatever else. So I don't know if I would go for that, but they do give you that option here. So you can look at the phone things there if you have phone signups. Okay, save attempts. This is another one that was on the plus column for businesses. The proposed rule had a provision in it that would have prevented presenting save attempts without first asking the consumer if you can talk to them about a save type of offer or give them an option to stick with the program, and then getting their affirmative consent to listen to that offer. So the FTC did decline to adopt that provision. They might look at it again. I don't know, Shahin, if you want to add more here and talk about the serious case.
Yeah, so a couple of things. So recently, I think it was in the past week or so, a New York State court just issued opinion in the case that the New York AG had brought against SiriusXM under both ROSCA and New York's automatic renewal law. And in that case, the court held that Sirius, as a matter of law, had violated ROSCA because it failed to provide a simple method of cancellation. When I say ROSCA, I mean the Restore Online Shoppers Confidence Act, which is the statute, not the rule, that governs negative option programs that require you to provide a simple method of cancellation. And that's it, nothing more specific than that. But back in 2021, the FTC had issued a enforcement statement that said that a simple method of cancellation needs to meet all of these boxes. And in the state court's opinion, they said that Sirius had violated ROSCA. It had violated the FTC's requirements surrounding providing a simple cancellation mechanism, because even though people could enroll online, Sirius required customers to contact a live agent to cancel. And then people would face lengthy wait times as a result. The other issue that the court cited in that case were save attempts. People were subjected to multiple retention attempts before the cancellation request was honored. And so the court cited the policy statement. What I think is really interesting about this is we just had this decision where a court said, hey, too many save attempts, that's bad. And then we've got this final rule that actually removed this idea of no save attempts are permitted without permission. And one thing that we keep hearing about this is that this is like the click to cancel rule, one click to cancel. It's not really the click to cancel rule anymore, right? It's provide an online cancellation option, but you're allowed to give save offers. The question now becomes, after the Sirius case, how many? How many is enough, or how many is too much? And so it's something that we need to keep an eye on. But when we're talking about unsung changes to the FTC's new rule, this idea of save attempts and the permissibility of save attempts and whether or not this is actually a click to cancel rule, that is unsung. We're hearing this. I think it's a complete misnomer. Not to say everybody on this call now we're all going to get a bunch of calls saying, oh, we can do 100 save attempts. That's not what we're saying. It's going to be very fact specific. But the idea here is that, as Ellen said, this is in the column of good for business. You are not precluded from doing save attempts under this new rule.
And even this is good because California provides some leeway on that too, as we'll see when we get to that piece of it.
Yeah. So we are going to go next. I've been looking at the questions and we haven't been able to, stop and get to them. We'll try to, but one person asked, what's the likelihood of this law going into effect? And we're more focused on California law changes. So that's actually coming up next. So we should probably go through the sort of the challenges to the FTC rule that are pending right now. We can do that relatively quickly, and then
I'll do that very quickly. I think this is all very so anybody who says that they could read the future and all that stuff, I take that with a grain of salt. I can talk to you about the challenges, but I cannot tell you what will happen. I think one thing that we all say who are do auto renewal stuff is that this is very unpolitical. As a general matter, Republicans, Democrats, and everybody in between, they don't like unapproved charges, and they don't want to have to bite their leg off to get out of the trap that is not a renewal subscription program. So a couple things that are going on. We've got 2 cases that have been consolidated that are pending in the 8th Circuit against the Federal Trade Commission's new rule. They're alleging that basically everything that they could allege under the law, that the rule is arbitrary, capricious, and abuse of discretion under the Administrative Procedures Act, that it's unsupported by substantial evidence. Anytime you have a trade regulation rule that's going to be punishable by the penalties of $51,744 needs to be supported by substantial evidence, or needs to be fact-finding here. What the petitioners are saying is that the fact-finding did not occur. I think the FTC did as much as they thought they could do to have a good record to do this. I personally don't think the record's developed enough to go as far as they did, and that's what the petitioners are saying. They also say that the rule was based on determinations that precluded disclosure of disputed material facts. In other words, if you're a company, if you're a trade association who had disputed facts, that you could go against the FTC and say, look, here are the facts that go against your quote-unquote finding that all of this activity is unfair, that they were not permitted to actually provide those disclosures to the FTC. And the last thing they're alleging is that the rule is in excess of the FTC's statutory authority. We're going to see a lot of this statutory authority arguments occurring under the new administration. We're going to see it a lot in the Consumer Financial Protection Bureau. We might see it in other places as well. Maybe it's the EPA. I don't know. But this is something that the petitioners are arguing in court in the 8th Circuit. They picked that circuit, I think, intentionally because they thought that that's where they were going to get the best treatment by a court, that the court is going to be a little bit more dubious of the FTC's authority as opposed to courts in other areas such as California or in the Northeast, for example. If they succeed, a couple things could happen. You could see some sort of preliminary relief. Let's just pause. The court says, you know what, FTC, you cannot enforce this while we're looking at the facts of all this. The court could say, I don't think preliminary relief is possible here, but I'm going to go ahead and evaluate this. And then down the line somewhere in a year or so, the court's going to say, you know what, one of these arguments is correct. I'm not going to let this rule be enforced. So that's another possibility. So we've got this pending through the courts. We're keeping an eye on this very, very closely. Follow our blog, sign up for the VAST list, and you'll get those updates as soon as we know them. The other thing that is a technical possibility here is a Congressional Review Act. It's a way for Congress to repeal or block agency actions. A lot of our friends and colleagues over at the FTC, we've had conversations with them. They think that the Congressional Review Act, or the CRA, is going to be used with some of the new rules that the FTC has been promulgated. What the CRA does, essentially, is it takes a final rule. Congress then looks at it and says, you know what, we don't like it. We don't want it to happen. We're going to repeal it. If that happens, the agency where the rule was repealed cannot issue a new rule that's in, quote, substantially the same form if that resolution is successful. What constitutes substantially the same is not defined. But what that means is that, let's say the negative option rule goes through the CRA process and it gets repealed, then the FTC is going to have a really hard time passing or getting through a new rule that is at all similar to what we're seeing right now, because substantially the same. They're not going to make tweaks. It's not going to be line edits. They're going to have to make some real changes. You can go through the slides and sort of see what the process looks like, but essentially what happens here is that a lawmaker can introduce a resolution of disapproval of the rule within a certain time period. There's a simple majority that's required for passage of that CRA resolution, and the president can sign, veto, or take no action on that. This is a political process. I don't know what's going to happen. My suspicion is that, people have asked me, my suspicion is that a lot of the other rules will probably go through the CRA action. Again, auto renewals are not particularly popular across the board, so I'm not sure what's going to happen there. You can see the timing here, but the long story short is that this is something that could be subject to a CRA action with the new administration, and we don't know what's going to happen. We're keeping a very close eye on it. Ari, let's talk about California, because that's where really the heat's on, right?
Yeah, it is. I just want to make one point about material disclosures based on some comments or questions that I've been looking at as they've been coming in. Here's a way to answer the material disclosure question in terms of what needs to be disclosed. Obviously, the price and all the other things that Ellen discussed. But you all know what is important to your customers given what you're selling to them. You know that based on research you've done, feedback you've received. you know what is important to them. And so for each good or service that you're selling, you're going to have unique things that are important to your customers. Those are the things that you should consider disclosing, even if the law doesn't technically require you to do so. What would a consumer be upset about if they were not told something, but find out something either different or later in the process after the fact? And because the FTC, if they start investigating and they think that there's something going on with the business, that's what they're going to seize on. They're going to find something unique about the business based on the complaints they've received during the investigation that they've done, seize on that and say that's material, and the courts are going to have to sort all that out. So that's a way of, nobody has a crystal ball, but think about what's important to your consumers. Okay, changes to California's automatic renewal law. This is something we've been talking about for a long time and watching. Again, it just moved from January to July of 2025. So the first change is something that the court system had already kind of implemented through the case law, and it confirms it. It's an automatic renewal law includes a free-to-pay conversion. So something that starts out for free, and then, if it's an electronic subscription to something, or even back in the days of nutritional supplements, something that starts off for free during a period of time and then automatically converts to a charge if you don't do anything to cancel in between the time of the initial free trial period and the time that is that the conversion starts, which obviously should be clearly and conspicuously disclosed. Talking about material changes, that's a material term. And here's the definition. So this is going to become official. This is something you should do anyway. This will clearly be covered by the FTC rule, arguably already is. But California is going to put this into effect officially, assuming that everything goes as planned on July 1st, 2025. So then here's the consent requirement. Companies have to obtain express affirmative consent for the automatic renewal or continuous service offer terms. So that means something that is an affirmative act, something that the consumer has to do to trigger agreement to the automatic renewal or continuous service offer terms. Call to action, it could be a checkbox. It has to be something. It can't be passive. You just can't show it to a consumer on a page and then have some button that does something else. It has to be expressed. Now, here's what's interesting. The amended law, or the prior version of the bill, stated that the companies must obtain, quote, the consumer's affirmative consent to the automatic renewal or continuous service separately from any other portion of the contract, which is kind of what the FTC rule is targeting at. And there was a thought at the time that this language, which has now been removed, required a checkbox. I didn't believe that, and I still don't believe it. But there's still a school of thought that the unchecked checkbox is required. Obviously, that's one way to do it. When we are advocating for our clients on this, we cite case law that says that a checkbox is not required. Never was in the statute. It's not now in the statute. The task force, the California Automatic Renewal Task Force, absolutely mandates it. And if you get caught up in an investigation with them and have to resolve it, that's going to be a very difficult injunctive relief term to negotiate out of, even with this change. So checkbox, I guess, is the gold standard, but I would argue 7 ways to Sunday that's not required under the law.
And that's right. And then there have been a lot of recent cases. The more cases that come out are the more cases that saying no checkbox is required under the current version of the law. I don't know why they added the word express as opposed to affirmative. I don't think the word express means checkbox, whereas affirmative doesn't mean checkbox. But I suspect that we're going to see some challenges brought where they said, oh, well, the legislator added the word express, and therefore a checkbox is required. So stay tuned. That's another area that we are keeping an eye on, and that is something that I do think is an unsung change here on the California side.
Let's go to the next one. So the amended law will prohibit companies from including any information. It's not just information; it could be any graphics, any dark patterns that detract, contradict from, or otherwise undermine the ability of the consumers to provide their affirmative consent. They really want to make sure. So it has to be like the neon sign in a dark room. Like that's basically what California is trying to do to get this updated consent in place. And they know, I think, pretty well what marketers do to try to focus consumers' attention on things that are less desirable for the company. So they're onto this, and that's why this was passed. Requires companies to maintain verification of consumers' affirmative consent for at least 3 years or 1 year after the contract is terminated. I would watch out for the 1 year after the contract is terminated, especially if you have consumers who have agreed to a subscription for multiple years after initial sign up. I think 4 years is the gold standard because of the statute of limitations associated with 17,200 and 17,500, which is what is being used to sue, class actions lawyers use to sue under the statute, because technically there's no private right of action under the California Automatic Renewal Law. It has to come in under false advertising law, the unfair competition law. Okay, so the updated cancellation requirements, saves, and retention efforts. This is actually, I don't know, do you think, Shahin and Ellen, but I think this is a positive development. So I want to focus on number 2 because we're kind of running out of time. That's the online system. So you may, permissible to display a discounted offer, retention benefit, save, or information regarding the effects of cancellation. You still have to prominently disclose and locate a direct link for the click to cancel, or words to that effect, with the presentation of the discounted offer. So you can't have like this massive save attempt or discount or whatever ad basically, and then have this like really small link at the bottom where it's hard for the consumer to find it. They're trying to strike the balance here, and I think this is showing some flexibility. But if the consumer uses the direct link or button, you have to process the cancellation right away. So you get like literally like this is like one save attempt. Shahin, what did I miss?
Completely agree. This is the one. This is like the one save rule. If I were to put a name on the I should trademark that. But yeah, what this says, it's good. It's good because we had plaintiffs' attorneys. God, how many letters have we gotten, Ari, where it says, oh, well, you attempted a save, so it's not an easy cancellation mechanism. And now the California legislature has made clear that a save is not an unreasonable impediment or obstruction to cancellation. But it does also say, so there's a good side of it, and the bad side of it is that, okay, well, if someone says cancel anyway, then you got to cancel them out.
Yeah, and like even before all this, like a lot of the complaints come in 2 forms. I didn't know I was going to get charged this for this amount of time, and I couldn't cancel. So like you want to have this because the people who can't cancel are the ones that are most, I don't know, I can't say that most, highly likely to cause problems. Okay, cancellation by telephone, we'll include this in the slides because I've got only like 1 minute. There are some rules for cancellation by telephone. We will continue to monitor the changes. The last set of changes from California, I think, were positive, in addition to the delay, which obviously is beneficial for multiple reasons. But that's our presentation for this afternoon. We had a great turnout. We thank everybody for coming to hearing us, speaking with us, and we look forward to seeing everybody soon at our next webinar. And by the way, if you have any ideas for us or things that you want to hear, like we're not here, we're here for you. So send us ideas, we'll put some together, and we'll probably see you all in the new year.
Thank you, everyone.